On the one hand, you have a will. On the other, a trust. These are kind of getting heavy. Hi, I'm Keith Wilson, founder of Wilson Financial Advisors. I'm sure you have heard of estate planning, but what exactly does that mean? Well, first of all, what is an estate? Simply put, your estate comprises everything that you own that is in your name only. For example, your bank accounts, investments, your home, your car, and other smaller assets. So an estate plan will have several important documents, two of which are your last will and testament and a living trust. So what is the difference between these two? A will is a document that states how you want your property, your assets, and personal belongings to be distributed after you pass away. It is one of the most essential estate planning documents. You can also name guardians for your children under the age of 18. A will takes effect when you die. You will name an executor to carry out the duties of making sure everything is distributed according to the will. Only property or assets held solely in your name can be distributed at the time of death. But before this happens, before assets are to be distributed, the will have to go through a process called probate. Now, this could be a lengthy process that would include the executor will have to file the will at the courthouse, receive letters of testamentary, file an inventory of everything owned in the deceased's name, place an ad in the newspaper for creditors, and file a final inventory. So once the will is filed, guess what? It becomes public record, and really anybody can take a look. Now, depending on the complexity of the estate, the probate process, it can take up to 6 months or even years. If you die without a will, then it means you have died intestate. The state will then determine who gets what from your estate. So by having a will, you are taking steps to ensure your wishes are carried out. Hey, if you have beneficiary accounts, such as life insurance, IRAs, or other retirement accounts, and you've named beneficiaries, then those accounts would bypass the probate process. There are different kinds of trusts that people create, but the most common one is the revocable living trust. Unlike the will, the living trust goes into effect immediately. Once a trust is created, then properties and assets, such as investment accounts and bank accounts, they're retitled to the trust's name. In other words, instead of John Doe owning the asset, it would now be owned by the John Doe Living Trust, with John Doe being the trustee. The trust only covers property that has been transferred to the trust. So listen, if nothing was transferred to the trust's name, then the trust is useless. The trustee can still move assets around, manage monies owned by the trust. But unlike the will, the trust can be distributing assets before death, at death, or afterwards. One of the most attractive features of a trust is that it passes outside that probate process. Hey, that can save time and money. Trusts are not made public, so it remains private. No one gets to see it. Now, there are drawbacks of a trust, which include they're more expensive to set up than a will. It can be time-consuming to retitle all these assets to the trust, and you cannot name guardians for minor children. So think at it like this. What you own and what is in your name comprises your estate. Your last will and testament dictates how these assets are to be distributed by the executor and will go through the probate process. If you had a trust and transferred those assets from your name to the name of the trust, then the trust document dictates how and to whom those assets are to be distributed to the beneficiaries by the trustee, and it does not go through the probate process. You will still need a will if you have a trust, but you can have a will without having a trust. Not everyone needs a living trust. If you're concerned about your heirs having to wait for funds after you pass away and your estate, being tied up in probate court, then take a look at what you own. If the primary asset you own is a retirement account, like an IRA or a 401k, and you have named beneficiaries, then by nature, those beneficiary accounts already passed through the probate process, and they could receive their shares very quickly. So it wouldn't be a concern about probate in that instance. Making your estate plan is very important, and there are other things to consider that we really didn't cover, so speaking with an estate planning attorney for legal advice would be a good idea. Now, if you have questions about this, or really any other financial topics, give me a call. I would welcome the opportunity to discuss your unique needs and circumstances.